Welcome to NJBIZ's monthly series of panel discussions on topics of importance to New Jersey's business community. My name is Howard Burns, and I'm the editor of NJBIZ. Today, we are examining a topic that's been in the headlines for most of the past 5 months: sexual harassment in the workplace. And to do that, I would like for our panelists to introduce themselves. Panelists, please keep it succinct. Thank you.
Good morning. My name is Meklinsky. I'm a labor and employment lawyer at Fox Rothschild. I'm co-chair of the Labor and Employment Department. We have about 90 labor and employment lawyers across the United States.
Hi, my name is Ciana Williams. I'm with the Mid-Atlantic Employers Association, MEA. I'm employment counsel there. I have experience as an employment litigator. We have about just over 500 member companies, primarily in New Jersey and Pennsylvania, that we provide with support on a variety of employment-related issues.
Good morning. I'm Peter Frattarelli from Archer & Griner Law Firm. We're a Delaware Valley-based firm, primarily out of South Jersey. I'm chairperson of our Labor and Employment Department. Generally represent management employers in these type of cases and all kinds of labor employment matters. Good morning.
Good morning, everybody. My name is Michael Owen. I am both the Chief Human Resources Officer and General Counsel for Easterseals New Jersey.
Thank you, panel. First question I have is a very basic one, and it is, if it weren't for all of the media coverage surrounding Harvey Weinstein, Matt Lauer, and all the other folks, would we even be having this conversation today?
Oh, these guys. All right. I think we might not be having the conversation, but we 100% should be having the conversation. Even some of the statistics, if you take a look in the article New Jersey Biz just put out, it's very clear that about 1 in 3 currently female employees is experiencing sexual harassment in the workplace of some form. And so both because it's the right thing to do, we should be having the conversation, but also because there are real practical things that employers can do to limit and reduce the risk of being liable for sexual harassment. They're very basic. The law in this area is very compliance-oriented. And if employers are complying with efforts to prevent harassment and to correct it when it does arise, they can dramatically reduce or eliminate their liability for harassment if it does actually happen in their workplace, because they've been taking the right steps to prevent it. So I think it's an area that we should be talking about from an employment perspective, both because it's the right thing to do and because there are real practical steps you can take to reduce your company's risk of liability. What do you think?
Wow. Good morning. I agree. Quite honestly, if you take a look at the history of anti-harassment law in this country and in the state over the last 20 years or so, it's pretty clear. I mean, it's incumbent upon every employer to have a well-drafted and implemented anti-harassment policy. The policy should have reporting mechanisms, effective reporting mechanisms. And while the law doesn't per se require, as a mandatory nature of your implementation of the program, in-house training somewhat akin to what's the law in California, where you have to have a requisite number of hours of training and then supervisors need additional hours of training. It's incumbent upon you to train and implement the policy so people understand the mechanisms that are there in place to solve workplace harassment issues. If you follow those steps, you're going to be better suited as an employer to avoid liability. I agree that it's a great conversation to have. My concern is that we've somewhat mixed, from a societal perspective, these highly publicized sexual abuse type cases with what I'll loosely call, the garden variety sexual harassment case. Whether it's someone who just treats men better than women in the office, or may act or tell inappropriate jokes in the workplace, is somewhat materially different than individuals who engage in these really outrageous, abusive type behavior that is so prevalent in the press today.
Yeah, I'll chime in as well. I certainly agree with all those comments. I will tell you, I think that in many ways, I think the notoriety that this has gotten through the press is probably, I don't want to say a good thing in the end, but I think a good thing for employers just to be aware and be reminded of. Certainly all my clients that I've talked to, we tell them about harassment, why they need to do harassment training, as Ciana and Ian mentioned. But there are a lot of employers out there that just frankly are not fully up to speed on this, and small to mid-sized employers don't realize what their obligations are. And again, it is one of the few areas in labor and employment law where if you take affirmative steps to put a policy in place, you can avoid liability. It's one of the few areas where you really do have some protections. And I do think it just raises enough awareness out there. Besides the fact that just having public awareness on this type of issue is a good thing. I think having that brought out to the forefront and having people understand that this may have been going on for years, for decades, what have you. So while I agree with Ian, a lot of these high publicized cases are more sexual assault or abuse, I do think it at least raises awareness everywhere for people to be out on the lookout for this.
Yeah, and in our worlds, we've been talking pretty actively about this subject for 20 years or more, including the time that we were all discussing as a nation, Anita Hill and Clarence Thomas. And so we might not be talking about it today, if not for the Me Too movement, but it's never going away as a workplace topic for those of us in this, end of the business. But we have seen this massive, high-profile outcropping of people coming forward and people making complaints. And what we have also seen is that notoriety and that publicity and that volume has generated a willingness for more people to come forward.
Gallup did a couple of polls, one in 1998 and one in 2017. And as recently as 1998, a majority of Americans said people in the workplace were too sensitive about sexual harassment. While today, 59% say people aren't sensitive enough. In 1998, 55% of women and 45% of men said sexual harassment in the workplace was a big problem. In 2017, 73% of women and 66% of men said it was a big problem. So what happened in those 20 years for those numbers to go up, in your opinion?
Well, I'll take a first stab at that. I think the numbers fluctuate, and I think they're both true. And so what we see is that depending on the mood of society or the mood of a particular workplace or the country as a whole, we see a shift in those kinds of things. From my own personal experience, the number of harassment claims that get made in workplaces where I've been pretty significantly, and maybe commensurate with the numbers that you're reading, are either unsubstantiated or substantiated, right? They're not all real, but they are all serious, and they do all call for what some of the other panelists have talked about, the process and the analysis and the review of the claims to make sure that they're handled properly. Society's view of what proper is changes, and that's one of the challenges that we all face.
Yeah, and I want to just supplement that point. One thing I always do when I do harassment training is I talk about it's a really weird dichotomy to me when you look at society versus the workplace. I always tell people that, in the 1950s, everyone remembered some of you will remember the Dick Van Dyke Show. Mary Tyler Moore, they wouldn't let her wear slacks on TV because they thought that was too sexy or too racy. And even the 70s, one day at a time, had some off-color comments about sex, and they moved this show to 9:30 because they didn't want those comments on at 8 or 8:30. I remember, I don't really watch the show much. It was Two Broke Girls, I guess. They were talking about some masturbation contest they were having. It was an 8 o'clock episode. So you combine that with Howard Stern, everything else you hear on the radio. So you just think about how society has gotten much more, just in terms of what's out there, what's publicized, whether it's certainly everything on social media. So that's going in one direction. And I don't want to say our workplace has gotten more Puritan and more pure, but certainly we're trying to be more respectful of women's rights, more respectful of harassment. So you have society going one way. But again, I think it's not that it's an excuse, but I think it's difficult to tell your employees who have a society out there that is very, I'd say, sexually charged and much more open about comments and commentary, to suddenly get to workplace and then shut off your morals and stop acting the way you did for the other 16 hours of the day. So I think that's part of the reason why I think we're seeing these trends.
So I just want to touch on something Mike said, just to elaborate on it a little bit, that when you're investigating a claim of workplace harassment, sexual harassment, very often the finding will be either these particular allegations were substantiated or not substantiated. But just because something's not substantiated doesn't mean it's not a real claim. It doesn't mean it didn't really happen. And that goes both ways, right? So someone claims something bad happened and a manager or another employee says, no, it didn't happen this way. Very often you can't substantiate either side, right? So the conclusion would then be, you can't verify either one. And there are certain steps that employers should take in those circumstances to still guard against and monitor conduct that's happening in the workplace. But also, keep in mind, because I think it's totally accurate to say, look, as a society, we're more sexually liberal. We are very coarse in the language we're using in the public environment, even in our politics. But it is true across the board that a lot of that language, a lot of that commentary, and a lot of those actions would be unlawful if they happened in the workplace under anti-harassment and anti-discrimination laws. And why is that? Well, think about it this way. Anywhere else, you can turn off the TV, you can leave. If you're at a friend's house and they start talking about what they saw on Two Broke Girls or whatever it is, you can say, I don't want to deal with this, and you can leave. But you are captive in the workplace. All of us are. You have to be there to earn your living, right? So these laws reflect that. And they say, when you are at work, you should not be subjected to this conduct, no matter what's going on out there. But it does create, I think, more risk for employers to a degree, because people see it. And I mean, in trainings, I'm sure you guys have had similar experiences, employees will say, you mean to tell me that what I see so-and-so saying or doing on TV, I'm not allowed to say that at work? And I'm like, oh, my training has been effective. I'm like, that's 100% right. You may find yourself meeting with HR or being subjected to an investigation if you choose to repeat those things in the workplace. So again, the sexual harassment topic we're talking about is sexual harassment in the workplace. That's different from sexual assault outside of the workplace that is in no way connected to work, or in the media you'll see allegations about sexual misconduct. Those things, those are held to our societal standards, and we decide we want to continue following that celebrity or not. But these laws and rules that apply in the workplace are there because typically our employees are, in a way, captive if they want to earn a living. Yeah.
So recently we conducted at our firm in-house harassment avoidance training for all of our attorneys and our staff. And training the staff is relatively straightforward. Just imagine training 850 lawyers on anti-harassment training when lawyers by nature are confrontational type A personalities. So the way I explain the difference in behavior and what the expectations are is that it may be okay to behave outside of the work environment, the way you see people act on TV and in politics. But the analogy I use is at work, you have to behave as if you're on the Starship Enterprise, right? Everybody wears the same uniform. Everybody behaves with the same appropriate decorum towards each other. When you watch Star Trek, you don't hear inappropriate locker room talk. And this is what the expectation is in the workplace. That is a very difficult standard to meet. But what I say to people when we do the training is that that's what the courts are expecting. If we all sat on a jury, we may have a totally different view of what is or isn't sexual harassment or racial harassment or age harassment or handicap harassment. But courts are the ones who are interpreting the law. And what you have to do as a lawyer and as an employer is take a look at it from the perspective of who's ultimately going to be the decision maker here and how are they going to view the conduct. And generally speaking, a lot of the law that we rely on are court decisions where appellate courts have interpreted what juries have done and have set out standards. But these jurors, for the most part, first of all, they're not employers in the traditional sense that you would expect. and they live in a highly academic environment. So they're not necessarily thinking through the implications of their decisions the way you would as an employer if you were the one making the ultimate decision based on how does this play out in the long run. And I'm not being critical of the judiciary and how they've come to their conclusions, but sometimes decisions have odd outcomes from a practical perspective in the workplace, and you just have to have these very stringent kind of bright line rules in order to avoid liability on behalf of the company.
Well, then that begs the question, is the compliance training that is being done by companies out there in general right now adequate to address these concerns?
Oh, there's a hand up. Should we? I'm not sure.
I'm not sure if I should have you answer that first, because I do have a question on compliance training.
We will be having a Q&A session afterwards, if it can hold that long.
Sure.
Okay, thank you.
So the compliance training, I view it as an awareness mechanism, right? Because employees, first of all, I think a lot of employers are focusing on providing this training now. A typical anti-harassment training is going to talk about what is unlawful harassment, what is sexual harassment. It should include what is unlawful discrimination, and what is retaliation, and the complaint process within that organization. And I think now employers are focusing on it a good bit. I mean, it has been done over the years, but not, I think people are having a heightened awareness of the need to provide it. And it has an impact because it makes employees aware and it puts tools in their hands in terms of what is appropriate and not. And I mean, I know that just from feedback in employee sessions of training, right? Where they very clearly did not know that some of the things they were doing in the workplace are not appropriate. And maybe they don't even rise to the full level of unlawful harassment or sexual harassment, but they, over time, could accumulate an amount to that. And I've had employees come up to me in sessions afterwards and say, can I share with you what I've been doing? Am I going to get written up? Because this, and I say, this is just providing you with information. This is not about catching you in a moment or someone going back and catching you in a moment. You now have the tools to know the appropriate guidelines, right? And sort of the rules of the road within your organization. So these rules exist whether employees know them or not. And I do believe that giving your employees that knowledge equips them to better help your organization protect itself.
Mark, thank you. I'm going to give you my HR hat on this for a minute. I think that they are adequate. The trainings that exist are adequate, and there are a lot of them, and they can be done, and they can be done annually, they can be done more frequently, they can be done for different groups. But the real issue at the heart of it always is the training goes away, and then what do you do as an organization when the training's over? It always comes down to leadership and management and the tone that they set and the buy-in that they create. And even in the highest profile sexual abuse cases that are almost outside of the realm of what we talk about, as Ian's termed the garden variety sexual harassment, right? What we see there is the tone set by leadership is one that condones the behaviors on the basis of the power, the responsibility, the work product that's generated by the people that are committing the bad acts. And if you have leadership being clear with its management chain all the way through that this is not what this organization's about, then that's the best kind of training that you can have, right?
Yeah, I certainly agree. I think that I feel the training that's been out there is adequate. I think the issue is, are you doing it frequently enough? Are you getting it in front of the right people? I certainly know the training I've done. I think every time I've done one, I've seen a face in the room or a look in the room like, oh, wow, I didn't realize that could be the issue. Whether it's I'm making a comment to a friend and I didn't think that somebody sitting in the next cubicle over might have heard it and might have been offended. Whether it's that or whether it's just explaining, what some of the boundaries are. I think it works and I think it's effective. I think the real issue is, are you doing it enough? Are you just doing it when entry-level people come in and not doing it again, not repeating it? And certainly, as Ian said, whether it's attorneys or managers or supervisors, to me, those are the ones that really need to be trained, your managers and supervisors, to understand how to react and how to respond to a complaint or an incident that's happening in front of them. The last thing you want to be in a case is where someone's alleging harassment and the evidence comes out that this was happening in front of supervisors all the time, and they did nothing or they ignored it. I think that's the worst shape to be in. You really do lose the benefit of the training and the defense.
Going back to, your original question about the Me Too movement, what I've found in the last few months is that when our clients have conducted their in-house training, people are feeling more comfortable about coming forward because of what's in the news. So I have clients who have called me up and have said, after we did the training, I had an employee come up to me and they complained about sexual harassment, and I'm not really sure what to do with the complaint. And I said, well, you have an internal procedure. Follow the internal procedure. And they said, yeah, except for the complaint is about a set of events that occurred, a decade or more ago. And in one case, I had one where it was 40 years ago that the woman now is complaining about it. And just because there's that difference in time doesn't absolve the employer from actually looking at it and dealing with it. And, luckily, these employers that have contacted me have been smart enough to say, we need to look at it and investigate it, but how do we do that when the allegations are, as I'll term it, stale? I mean, it's, people's memory. I have enough trouble remembering what I had for lunch yesterday, let alone what I may have said to somebody 20 years ago. But regardless of the time frame in which the complaint is made, you have to go and investigate it. And interestingly enough, and I think this is also part of maybe some of the difference we're seeing in the political sphere today, I've had cases where, when challenged, the male supervisor has admitted to the conduct 20, 30, and even 40 years later, which makes, by the way, the employer's job incredibly easy. Goodbye. So just because people are coming forward with delayed complaints doesn't absolve an employer of the obligation to investigate it. It may make it more difficult, but you have to do it. And I see that because of the training, a lot of employees are coming forward with complaints that have been sitting around that they've been uncomfortable bringing forward, but are now bringing forward. And the good part about that is if you do have a supervisor who has a pattern of behavior that you don't know about, it opens the door to learn about that person's behavior and can, provide you a defense in terms of the process that we talked about earlier.
On the topic of supervision and management in companies, there was a significant ruling, by the New Jersey Supreme Court in 2015, Aguas versus the state of New Jersey. Can I ask you folks to explain what that decision actually meant for workplaces in New Jersey?
Yeah, someone's.
This wasn't mine.
Oh, it wasn't. Someone wanted to talk about this case.
It wasn't mine either.
What?
Have at it.
I'm sorry, I don't remember. Is Aguas the individual liability? Sorry. Yeah,
I'm not.
I apologize.
Yeah, okay, we all talked about this beforehand, potentially, but then maybe we've said the wrong case. But, yeah.
All right, I'll tell you what I've got here.
It's called Stump the Panel.
Yeah, stump the panel.
This reinforced the need for employers to implement and enforce meaningful and effective anti-harassment policies while also expanding the definition of who is a supervisor and thus broadening the pool of those whose conduct could result in employer liability. That's
what I thought it was, but I just before I start babbling on, I figured I should make sure, right? Aguas dealt with two issues. One is that there's a healthy debate, I think, going on among the Labor and Employment Bar in New Jersey about whether training is mandatory. I certainly think it's highly, highly recommended for managers and supervisors. I've had some attorneys tell me that it's a per se, so to speak, case of liability if you haven't trained your managers or supervisors. This case certainly heightened that and emphasized that training is important. Whether you have to extend that to your staff as well is also an issue that case talked about, or at least suggested that training is important. So that was one aspect of the case. The other aspect of the case was who was a supervisor. Because as we haven't spent a lot of time delving into the law here, but the law here is relatively clear that if a coworker harasses a coworker, the company is not going to be liable for that. Even if it was what would be considered sexual harassment or a hostile work environment, the company's not responsible for that if the company didn't know about it, and if the company had a policy in place prohibiting harassment, giving that person an opportunity to complain, and they didn't take advantage of that policy. So again, if you have a handbook, you have a policy, procedure, harassment happens and it never gets reported to management, then you can avoid liability because it wasn't brought to your attention. However, AGWAS really emphasized and opened up what the definition is of a supervisor, whether there can be both, there certainly can be individual liability in New Jersey, but also expanded the definition of who's a supervisor, not just to your classic, upper management, middle management, but even to people who would be, I'd consider, what's the best analogy, a line foreman, so to speak, or someone who's kind of on the first line. They may be on shift work with them. Maybe they don't have a whole lot of responsibilities for discipline, for example, or not a whole lot of responsibilities for hiring or firing. But if they're overseeing your hourly workers, so to speak, overseeing your staff, they would be considered a supervisor as well under AGWA. So again, the importance from that really, again, is what's within the company's sphere of knowledge. If you expand the group of people who are now your supervisors, you lose that, the training you did, the policy you put in your handbook, the policy that's posted, you lose the benefit of that if the supervisors knew about it and did nothing. That defense goes out the window if it's within the company's sphere of knowledge. And as I always say in my training, whether it's that very frontline supervisor all the way up to the CEO, once someone in management knows about it, that's the same as if the company knew about it. And that was really the significance of that opinion.
Thank you. So in the wake of all of this publicity, high-profile publicity, some local lawmakers have decided to introduce legislation that could have a profound effect on how these kinds of cases are handled going forward. And I'll give you one example here. There's actually a couple. Senate Majority Leader Loretta Weinberg is spearheading a bill that would ban employers from entering into non-disclosure agreements with employees so those who have faced harassment can speak publicly. Why is that a good thing? Is that a good thing?
My buddy Loretta Weinberg. I think our legislators need to be a little cautious when they go into this area of the law and try to legislate without really thinking about the implications of what they're doing. Loretta's bill is really being pushed by the Plaintiffs' Employment Bar in New Jersey. And what the bill says is that if there's a claim of sexual harassment or abuse, a claim, and it is resolved between the employer and the claimant, that it is prohibited to have a confidentiality provision in the settlement. And why is that a good or a bad thing? Well, the plaintiff's bar says that's a good thing because a claimant should be able to settle with the company, take the money, and then broadcast to the world the alleged bad acts of the harasser. And the examples that the people who are pushing for this legislation give are the Harvey Weinstein cases, the Roger Ailes, the Bill O'Reilly, the Steve Wynn, these really public, and for the most part, more sexual abuse than sexual harassment, but they lump it all together. And they use it as a mechanism to say, and they say primarily women should know when they go to work in a certain workplace, they should be able to know what kind of environment they're walking into. Okay, I get it. I think that is a fair position to take. What a lot of lawyers, both on the management side, which is me and Pete, as well as, well, and you as well, I'm sorry, but as well as a lot of the plaintiff's bar Well, you're kind of, you know.
Oh, you were good.
And a lot of members of the plaintiffs' bar say this is a really bad idea. And why is it a bad idea? One, because sometimes the victim doesn't want the employer talking about it. They want their privacy as well. So that's one reason. Two, the employers that Pete and I represent, and everyone else, when I'm representing an employer and they're being either sued or it's pre-sued, where there's an allegation of sexual harassment, our clients are making, for the most part, an economic decision. Do I resolve this claim and put it behind me? Or do I engage in litigation that can take 2-3 years, a tremendous amount of economic resources, and a tremendous number of people hours in terms of defending the case and a distraction from our business? And what they make is an economic decision. And they're, more often than not, the goal is to try to resolve the case instead of litigate it, because in the long run, it's just too expensive to do it. If I say to a client, if you go to settle this case, you're going to write a check to your former employee and to their lawyer, and then they can take a billboard out on the New Jersey Turnpike saying how bad of an actor you are. Do you honestly think my client's writing that check? So I think it's going to interfere with the ability to settle cases. There are other mechanisms that can be implemented to achieve the goal that the bill sponsor is trying to accomplish. But what they're doing is they're taking, this broad brush stroke in an knee-jerk fashion to solve a problem that, quite honestly, really isn't a problem. Because if you want to make it public, don't take the company's money. Litigate it, go to the press, go to trial, and if you win and the person is a recidivist bad actor, you're going to get a punitive damage award that's going to be through the roof. But this bill isn't the only knee-jerk reaction to it. There's another piece of legislation, and then I'll pass the mic real fast, I'm sorry, is in the process of the new federal tax law, our state senator, Bob Menendez, did something without really thinking it through. He introduced an amendment to the tax bill that says if a sexual harassment or sexual abuse claim is settled, resolved between an employer and an employee, and there is a confidentiality provision in the agreement, the payment to the alleged victim and all of the attorney's fees paid out to settle the claim are not tax deductible by the company. There is not, by the way, another provision in the tax law that says anything remotely like that. But what he didn't realize, because he didn't think it through, is he just hurt the alleged victim, the victim of the crime here, the harassment. Because the way he wrote the bill, the amendment to the tax code, is that the woman who receives, and I'm using a woman generically, it could be a man, the victim, the money that they get, they were able to take a tax credit for the amount of money that they then paid their lawyer. But the way the amendment was written, and the way the law was passed, is that the victim can't take that tax credit any longer. So the windfall for the federal government is the victim pays tax on 100% of what gets paid out, and then the lawyer, who gets a percentage of what the settlement is, has to then pay tax on what they get. So here's an example. Let's say you pay $100,000 to a victim to settle a sexual harassment claim. And let's say the lawyer's fee was $30,000. It used to be that the victim would get taxed on the 100, but take a $30,000 tax credit, and net only pay tax on the 70. The lawyer would get the 30 and pay the tax on the 30. Thanks to Bob Menendez, the victim now pays tax on the full 100, and the lawyer still pays tax on their 30. So the federal government gets double taxation on that set part of the money. And when challenged about it, he actually said that he thought the Republicans would figure that out after he made the amendment and would fix it. So lo and behold, today we have this new tax problem because it was a knee-jerk reaction to try to penalize companies for settling with confidentiality agreements without thinking through the ramifications of what the alleged solution to the problem is. So I think we really have to take a look and put all this stuff into some perspective and say, let's take a step back and what's really going to fix the perceived problem with the system instead of just throwing things out there on a knee-jerk basis.
I totally agree that knee-jerk reactions are not always well thought out. A lot of things that happen in the tax code are not always well thought out. But something to keep in mind, I don't want to leave anyone with the impression that confidentiality provisions in a settlement agreement with a victim of harassment or potential victim of harassment are going to be viewed favorably or enforced necessarily. And that's because the EEOC, the federal agency, and we talked about, I know you're aware of this too, but the federal agency that oversees violations of the federal anti-harassment laws views them very unfavorably. So very frequently, almost always, those provisions should contain an exception, those confidentiality provisions that says, yes, we're settling this matter, and of course no one admits to any wrongdoing on either side. However, the individual retains the right to file a charge with the EEOC, and that he or she will not receive any compensation as a result. So the pending legislation on confidentiality provisions would not, it could change things in New Jersey law, but you also have to be concerned about federal law, and federal law in a way is already addressing this. Same thing with these standards for liability with respect to harassment that occurs from one employee to another and from a manager to an employee. So some of the defenses that are available, one of them, when there has been harassment among or between employees and a manager knew or should have known about it, it requires you to also show that you took reasonable efforts to prevent or correct harassment in the workplace. And those reasonable efforts are training your entire employee population. So I'm one of those people who thinks everyone should be trained. They don't receive the same training. Managers certainly receive a longer, more robust training that reviews, for example, the fact that you can be personally liable as a manager within New Jersey, Pennsylvania, and several other states for harassment that occurred on your watch. So in addition to a company being held liable, an individual could be held liable, and that is a pretty big incentive to be aware of the law and comply with it for managers within your companies. But that being able to show you made reasonable efforts to prevent and promptly correct any behavior means showing you had a policy, showing you had a complaint mechanism, and you made it available to everyone. They knew about it, which is also something that's covered in the training. So you're proving, again, we made it available to people. And you very often, and this has been for years, you see an uptick in complaints after you train your employees on anti-harassment laws. But that's a good thing for a company. One, because they can stop the behavior. Two, because they can now investigate, resolve, they can have a process for addressing it. And it's possible that they might never incur liability for that, even if it happened, because they're taking all those correct steps. So employers sometimes have this reaction of, and lawyers too, I think, we think, oh gosh, we don't want complaints. We don't want people raising complaints. But in this area, it's actually great to kind of get people, shake things up, get those complaints out, investigate, address them, and move on. And you're protecting yourself in that way.
Let me just make one really quick point about confidentiality. There's a big difference to my clients, confidentiality about what happened versus confidentiality about what we paid to settle the case. My clients, frankly, particularly if a complaint's filed, they go to the EEOC, the allegations are out there in the public. So typically we're not all that concerned about preventing them from talking about what happened. What we're concerned about is preventing them from talking about what we paid to settle the case. So that's why you really have to be careful when you hear these cases that, conflating two things. For example, this, the woman who allegedly had an affair with the president, Stormy Daniels, yeah. She signed the allegations, I'll just say the allegations are they had a consensual affair she was paid off and signed a non-disclosure agreement. That's different than what we're talking about. We're not talking about settling a lawsuit. We're talking about, I'm going to pay you money just to shut up, which you can do. If that's a contract, you can enforce it. That's not what we're talking about. What we're talking about are claims are made, we're settling it, and what we don't want other employees and plaintiffs bar particularly to know is that we paid money just because you made an allegation. As Ian said, there's a lot of reasons you settle cases. Sometimes the facts are bad, sometimes it happened. Other times, I tell my attorney, tell my clients, you have a wonderful case and you can pay me $150,000 to prove how wonderful your case is, or you can pay $25,000 and make this thing go away right now. So that's a lot of times the conversations we have and why these cases are, it's so important to us, however, not to have 8 other employees at the doorstep saying, well, wait a minute, all I got to do is make an allegation and I get paid $25,000. So that's the reason why we want the amount kept confidential. The facts, they are what they are.
Is there a worry, given all of this high profile that's come about, is there a worry that employers may feel compelled to take swift actions against employees who have been complained about and perhaps doing that without due process?
I started my career long ago as a public defender, so part of what has influenced my work in human resources and the law is that concept of due process and fair treatment. One comment that I'd make about some of what we've also discussed is we're all, on this panel, we're all fortunate to have the jobs we have because these areas are so complex, right? And for small businesses or medium-sized businesses, they're especially complex because you usually don't have somebody like us sitting around to advise you all the time. One of the big and most significant pieces of advice that I give people when I talk to them is with regard to people in your business, you don't necessarily always need to know the laws and the complexities around the laws. You mostly need to know what you learned in kindergarten, and that is that if you treat everybody the right way, regardless of whether they look like you or think like you or act like you, and you go a little extra, when you can, when you have a decision to make, or, there's an opportunity, if you treat them really well, you mostly steer clear of all the laws, no matter how much they change, and you also are doing a good thing for your business, because that tends to be good business. So that's certainly advice that I give. With regard specifically to your question, we do see, and I have seen at every stop that I've made, I've worked at 4 major employers in significant HR roles, all of which have been different, and they've always struggled with this feeling, what is zero tolerance? What is zero tolerance? And some places say there's zero tolerance, and then they feel like no matter what it is, they've got to treat it a certain way. The person has to be fired. The only way to be safe is to be fired. But that's not what the trainings tell us, right? That's not what it really is about. And in a case like the sexual abuse case, where we're seeing such high-profile news on, we all have a reaction to that. And in those cases, it typically is the victim's. But in a lot of cases, it isn't. In a lot of cases, there is a reasonable ground. Thank you. And a decision to be made. Thank you. A decision. Ooh. Oh, okay. So there's a decision to be made by the organization on these cases. And the main thing to do is to go through the appropriate process. Management is able to decide, back to one of my earlier points, maybe it's a he said, she said situation, or a she said situation, right? When you're dealing with facts that may or may not be quoted one way or another, management can decide if this happens. It can make a decision on a basis that says, well, you know what, I believe this person. And making a judgment on the totality of the circumstances is always going to be the best thing. One of my most valued mentors had a sign in the office that said, it depends on situation. Right? We all want bright line rules, and we all want to know what are we supposed to do in this situation. And I work in an industry that's very highly regulated and is significantly mired in compliance compliance, the laws around compliance and regulations. And they're often frustrated by me being in the role that I am and saying, well, we've got to look at each situation. We want to make the right call. We have to look at each thing on its face, on its particular set of facts to make the right call. And then you have to have people making the decisions that are about the right things. When you're about the right things, you're leading the right way, and you make the calls on the basis of looking carefully at all the circumstances, then you're in the best place. And that's always the best idea.
Now, that's great points. And I think it's easy to say during training, you know what, when everything's equal, just fire the perp, right? Fire the alleged harasser because it's a tie and he can't sue you for anything. So you're better off firing the person who you're not sure if it happened or not. But that's a very, very dangerous and slippery slope because what that means is you've now set the bar lower and lower each time the next allegation comes in. And on top of that, forget about the law. It's bad for morale to have that happen. What I think is most important is just make sure your investigation is thorough and complete. What you don't want to have happen is you do an internal investigation, you talk to 4 witnesses, you can't decide, you decide maybe a reminder is all that's needed, I couldn't corroborate it, and let's move on. Then when you end up in court, there's 4 or 5 other witnesses that you should have talked to. Maybe they worked on the same shift. Maybe they were brought up by one witness and you didn't follow up. That's where the real danger is. You have to make sure you investigate it. It's a thorough enough investigation that you feel confident you've gathered all the facts, made a decision based on, as Mark said, the totality of the circumstances. You want to make sure you're making a decision based on all of that and not find out later that it was a rushed, hurried, and not thorough investigation. Then you would lose the benefit of that defense because it was not an adequate investigation.
Yeah, absolutely. And on the investigation point, so, and to your original question, so a lot of what we see in the media is well outside what any of our clients would do and what would happen within any of your organizations, right? Is we learn about the allegations one day and the next day someone loses their job. This is another thing that can be driven home to employees in a training session, that is not how it's going to work. And it's important both for the accuser and the accused to know that there are going to be investigative steps taken. And when we say investigation, it just means fact gathering. It just means fact gathering. And it's really important to have a process in place to do that because it can both, as you just mentioned, it can compromise your defense in that particular matter, and it can compromise your ability to defend against claims down the road if employees, they shouldn't know about it, right, because it's a confidential process. But should they learn that you sort of do lackluster investigations or nothing in response to concerns that are raised, they can later say they never performed adequate investigations. They didn't take reasonable measures to prevent what happened to me. So it's not only in that particular matter that you could compromise your ability to defend yourself, but in future matters as well. So it's really, really important.
I agree with everything, but I think going back to your original comment, I think some employers, because of the current environment, have been on occasion quick to dispense with the due process. And when we were on the phone last week, I gave an example, and I'll give it here. I'm going to say it somewhat slowly so I make sure I don't give up any names. A client calls up and says, we're an employer, we're a private school. We received a phone call from a woman who said that when she was a student at another school, one of the teachers at the new school that called me, hope I didn't lose anybody there, sexually abused her. And in light of what's in the news, she thought she should bring it to the school's attention. And the head of school calls me up and tells me this and said, yeah, we can't have this person on our staff. I'm just going to go down the hall and fire him. I said, well, wait a second. First of all, when did this occur? Last year, 2 years ago? When? 40 years ago. I said, okay. Have you had any complaints about this teacher in the 10 years that they worked for you? Nope. Would anyone describe him as creepy? No. Totally, nice guy, hardworking, blah, blah, blah. I said, all right, well, before you fire him, maybe you should talk to him. So they said, okay. I said, look, I have to go to a meeting. I'm going to get in my car, go talk to him, and call me. Half hour later, they call me up, and they said, we talked to him. I said, okay. They said, are you driving? I said, yes. They said, can you pull over? I said, okay. I said, what? They said, we confronted him, and he admitted it. I said, he did what? Now, that's a defense lawyer's reaction. Like, you know, he admitted that yes, he said that he had a weak moment 40 years ago. He did something he knows was wrong. He's come to grips with it, and he's totally accepting of any, ramifications of his conduct, period. So I said, all right, so what are we doing? He said, oh, no, we already fired him. But I get it, but I would classify that as kind of the unusual case where someone 40 years later says, yeah, I did it. But they, just on the allegation alone, and I get it, it's an incredibly serious allegation. It's in the context of a private school. It's sexual in nature. But, don't throw the baby out with the bathwater. Take a step back and say, well, what's the process, right? Follow your process. Do the investigation. Do the fact-finding. And they did it, and they came out the exact same place. But I know, and we all agree, that if you're the alleged harasser, you have very little rights, and you can be fired, But there are a couple of court decisions out there that do call that into question as to whether or not the employer did a non-negligent investigation. Because, if I'm an employee and I'm losing my job because of what someone else said, I think the employer has a due process obligation to at least treat me fairly in the process. And while the law doesn't technically require that, I think as an employer you're better off if you do that and follow your internal process.
So I'm going to give the same caveat, Ian. I hope it's okay, because Ian can only say but so much, since this was an actual matter that he advised on. Keep in mind, in the school context, when you have someone raising concern about abuse towards a minor, that's an entirely different context from workplace harassment. Though, conceivably, it could come up in a workplace harassment case if he ended up harassing someone, a coworker, and they, through discovery in a court matter, found out that the school was aware of this individual's, at least a concern being raised about his prior conduct. But when we're talking about minors in a school environment, there are all kinds of additional concerns, and yeah, that don't necessarily implicate workplace harassment. Yeah.
All right, I'm going to open it up to the audience now for some questions. You've been so patient that I'm going to start with you first. So what is your question?
It was already answered. Sorry.
Oh.
Well, I guess we did our job. Yes, ma'am.
So I started the conversation here at the table before the presentation, and you just reminded me with the "it depends" remark, because we recently had an in-house training, and where we found confusion, and we were strictly talking about harassment. I think all of us actually understand sexual assault, issues with minors. We were talking about this concept of harassment, which seems nebulous because it seems to be very much an issue of perception, the perception being the person who says they were being harassed. And I'm just hoping that perhaps you can give either some more examples of what that is, because I think that's the one that actually, to us, it felt like wibbly wobbly. We couldn't actually get our hands around it.
That's a great question. And just so everyone hears, the question is, how do you really understand what is sexual harassment in a workplace? How is that determined? Ian, I think, hinted at it when he said, ultimately, your fact finder, your judge, your jury is going to be the one deciding. But within the workplace, so essentially conduct in the workplace, sexual harassment is unwelcome conduct based on gender or sex that's severe or pervasive enough to change your conditions of employment and make it an abusive environment. Whether something rises to that level of severity is going to be judged from two perspectives, both a subjective perspective and an objective one. So subjectively, from the point of view of the person experiencing it, so that person, did that person feel offended, violated, okay? And objectively, from a reasonable person point of view, would a reasonable person feel offended or violated in that situation. So there's a balancing built in there, built into the law right there, that sort of, it will weed out anyone who wasn't actually offended, and it will also weed out an overly sensitive person. By its nature, right, this reasonable person standard is directly tied to our community standard. Okay, so it can always be changing, to your point of it being difficult to understand, right? It can always be changing. But there are certainly very clear instances of sexual harassment, like quid pro quo. You provide me with this, you sleep with me, you get this job benefit. There can also be implied acts. For example, I was aware of a company where, and this was in a non-privileged capacity that I learned this, a manager who managed the intern program at the end of the internship was giving gifts to all the female interns for Victoria's Secret. And everyone in that Ian, I'll tell you why it's inappropriate later. So everyone in that situation could be offended, right? The people getting the gifts, the interns who didn't get the gifts, anyone at the company who knows that a manager with firing either influence or decision making is factoring into his workplace views whatever he's implying with that gift. So just some examples of, and that doesn't necessarily, I'm not saying it rose to the level of quid pro quo or that it rose to the level of unlawful harassment, but anything along those lines. And the standard you're using, and I'm sorry, and then I'll stop and I'll pass the mic, but the standard that you want to use within the workplace about conduct you're seeing or that you're engaging in is not, am I at the full level of unlawful harassment? Am I sexually harassing someone? No. You want to make that standard much lower, right? Because you don't want to get to that point, and because less severe conduct, always, touching someone, or here, let me rub your shoulders once a week. That's happening frequently over time. That certainly can amount to sexual harassment. So you want to just avoid conduct that's even going in that direction.
I just want to add to that the question you're asking is very much what we run into all the time and what my prior comments were about, this desire for what is it exactly? Please tell me what it is so I can do the right thing about it, right? And you hear some great examples, and this is what the training tells you, and then you've got to be out in the real world and decide whether it is or is not something that qualifies as one of those things. And the examples that we deal with in the real world are not always as clear as some of the ones that we use to train, right? And so ultimately it then becomes your call as a business to say, how do I evaluate this? What do I think? What do we want to be about? Is it so obvious that I don't have much of a choice? Or is it something where there's I need to think about it? And putting us as leaders in the position where we need to think about it to make the right call often makes us feel uncomfortable, but ultimately when there's people involved, there's almost no place else that you can go. In the end, it is a call that has to get made.
Yeah, and I think that the one big fact I always look at when we do these investigations, obviously somebody makes a really offensive comment, that's one thing. But the issue is it pervasive? In other words, is it just the environment out there? When you start talking to witnesses, is this the sexual innuendo every time somebody makes a comment? Oh, that's what she would do, or those kind of things. Is it just a one-time occurrence, or is this something going on regularly on a frequent basis that is causing that environment to become toxic?
When I talk to people either internally in my organization or at my clients' organizations, I say, if you're already getting to the point where is the conduct harassment or unlawful harassment or not, you're screwed. It's already too far down the path. So quite honestly, the analysis I try to impart to people is you need to have a professionalism standard, okay? Whether something's sexual harassment or racial harassment or not, it's kind of like what the U.S. Supreme Court has said about pornography. Like, we know it when we see it. Okay, well, that's very helpful. But you have to take a look at it and run your workplace in a professional manner. That means that there's not this quote-unquote locker room talk. You don't, even among, if you have three guys standing at the water cooler talking about their weekend, it's inappropriate. I know sometimes it's unrealistic to kind of impart this to people, but when you impart it as part of training and say, this is unacceptable, you don't stand around the coffee machine in the lunchroom talking about your sexual escapades for the weekend or telling racially charged jokes, or you just don't do this. You come to work, and to act in a professional capacity and manner with those who you work with. And I think that's the starting point. And if you go past that, then you go to what Pete was talking about. Is it pervasive? Are they doing it all the time? And then you look at it, because it's really the rare case where something is so crazy over the top that it's a one-time event that justifies some termination or severe disciplinary action. What the cases we're normally looking at are these constant, sexually charged jokes in the lunchroom, or, the male supervisor who's gawking at the assistant, the receptionist all the time because of the manner in which she dresses, which is she can dress any way she wants as long as it's in the dress code of the company. So it's acting professional is really the starting point. And if you get to we're talking about whether or not it's harassment, you already have one foot in the ground.
Oh, boy. Yes, ma'am. Yes.
Okay, so, Ian, what you were just talking about was something that I had a question about, which it speaks to the larger conversation. And my question initially was, is having the compliance training enough to be able to say, check a box, yes, we've done all that we can as an organization to train our employees on preventing sexual harassment? And so you're speaking about a larger, I think, conversation that needs to take place around it, which is about what is management demonstrating, how are they embodying professionalism, and it just feels like to me that there's a larger conversation that checking the box on compliance might not be enough, especially if you're calling it sexual harassment training as opposed to prevention or awareness.
So the question is just having the policy sufficient to tick off the box to address your potential, I'll call it, cultural issues and your defense of a claim? The answer is no. Just having the policy in and of itself, in my view, and I think the other panelists would agree, is not sufficient. You have to have a corporate culture, because we've talked about it in bits and pieces during the morning conversation. You have a policy. You explain to people what the policy is. People are still afraid to use the policy, right? So you have to have a culture that entices people to come forward when they have a legitimate concern, and then you have to do something with that. So whether someone comes to you and says, I'm trying to think of an example here, Joe, my supervisor, yelled at me this morning. Okay, well, why did he yell at you? Right? Well, I'll use a law firm example. We had a filing deadline at 5 o'clock yesterday, and I didn't get the paperwork filed in time. Well, of course he's going to yell. But is it that Joe yells at Susie, his assistant, every day, but treats all the male associates or assistants, by patting them on the back all the time? You have to look at the culture and the pattern, and just having the policy isn't enough. And I think part of the problem is people are afraid to come forward. So you have to have a mechanism for people to feel comfortable to come forward and to address it. And one of the things we really haven't addressed this morning is the anti-retaliation provisions of the policy, right? You have to make sure that when someone comes forward that they know that they're not going to be retaliated against for bringing the complaint, even by the supervisor who they're complaining about. And more often than not, that's the bigger challenge. And that's the bigger problem that we have to deal with, because, when you go to a manager and you say, these subordinates have made a complaint against you about sexual harassment, and the male supervisor says, I don't know what you're talking about, and then all of a sudden those employees get the crap assignments going forward, that's the bigger problem. Because retaliation is much easier to prove than the underlying harassment.
Hi, good morning. My name is Connie O'Neill-Rose, and I work for Shift HR Online Compliance Training, and we provide online training to prevent harassment side of the story is I'm a mother, a baby boomer mother, who's a professional throughout my career. And I have 3 millennial daughters, and they are now professionals. And the good news is that they're much more enlightened and empowered than I ever was. And as it relates to companies and employers and corporate culture, they're not going to go to work for a company that doesn't treat their employees well. It doesn't have a corporate culture that's inclusive and diverse, and doesn't have policies in place for equality for women. So what's interesting is, in this discussion, we talk about what the companies are interested in checking the box on protecting themselves from, yet still the ROI is really, can you attract and retain talent moving forward with the new millennial generation who's enlightened? That's a good thing.
I think that's a really important point. And I wanted to say, we are up here talking about the things that can be done to check the box. One, because they are meaningful, but also because they're the things that can be easily controlled. So as an employee, it's not always easy to say, I'm going to change the entire corporate culture, right? That is very top down, and it's a discussion that should be had. And I know that CEOs and presidents, many of them spend a lot of time working and focusing on their company culture and an organization's culture. But in terms of tools that they can use to create that kind of diverse workplace where millennials and others want to come and work and stay, this is certainly part of it. And I wanted to semi-apologize to our previous questioner, because a lot of us attorneys and HR professionals who provide anti-harassment training often just refer to it as harassment training, but the full title will be something along the lines of avoiding harassment and discrimination in the workplace. But I think every single person will say, oh, we're having harassment training, and it's not necessarily correct. And so sort of changing that verbiage is probably a good idea as well. But yeah, so there are studies that show productivity and engagement among your workforce, to your point, increases when you have greater compliance with the laws in these areas. So they go hand in hand, and it's a great thing. And I think you mentioned that too, that cycle of, Yeah,
I mean, corporate culture is the main thing, especially as you get larger. It's the main thing that drives your success. And we spend a lot of time on that. And there's nothing, not to denigrate the concepts of compliance. They're essential. The laws that we follow are essential. They guide everything that we're doing. But the reality is that your business succeeds on the basis of how you treat people generally, right? And whether it's done the right way, and what your leadership is doing around that, and what kind of example they set, and how they enforce that example. And ultimately, even as I said earlier, even in the high-profile cases, if you want to look at a Fox News, what you see is a corporate culture that encourages and condones bad behavior, not a corporate culture that says absolutely not. And there's no amount of, I'm sure, if we looked at, I'm not sure, but I believe that Fox News has probably done plenty of compliance training around anti-harassment, right? And so it really doesn't mean anything other than that it's another box to check on your way to changing your culture to one that is about the right things.
Yeah, I always felt that one of my crazier ideas was always to have like a scared straight harassment training, where you'd have bring the harasser who got fired and lost his job and his house and his wife and his kids, and say, look what happened to me. This could be you in 10 years if you keep it up. Yeah, Roger Ailes going into Fox News to do training. That was always one of my crazier ideas.
That's a really good idea.
Yes, sir.
So, and by the way, thank you very much for holding this, because it's a very topical topic right now. But secondly, we have 4 attorneys sitting outside. These guys get paid. Now, my name is Paul Smith, and I work with the insurance office in America. The one item that wasn't addressed today is how do we pay these guys? First and foremost, employers, make sure your EPLI, employer practices liability insurance, is up to date. Talk about having the proper procedures in place, the proper wording to do the training. Things fall through the cracks, and people are going to do what they're going to do to pay. You need to protect yourself as an employer, look at your EPLI, and make sure you're covered. Of course, you have some insurance company.
I was going to say, insurers don't get paid. Also, I work for a nonprofit. No, but it's an important point. Absolutely, yeah.
Thank you for raising that. Sir,
I'm not going to give a commercial on who I am or what I do. But I'm going to ask something I've been really grappling with for a number of weeks, and this is coming from a dad of 2 daughters. And there's a lot of, there's a reality that we all have to deal with, and that's the mass majority of CEOs and supervisors in this country are still male. I mean, you guys as panelists are great, but 3 out of 4 of you are male. So my worry and concern for the future of daughters, do I have to worry about my kids not being able to get a job because a male doesn't want to potentially put themselves in a position of being accused of something? How can we avoid that? I think that you guys can talk me off the ledge and say that I'm worrying about something that's...
Well, I think, first of all, it's very presumptuous of you to think that the 3 of us are really male, but that's a whole other thing. You never know. Don't prejudge.
So you went there.
But nope.
I went there. You baited me. I went there. I think, well, I'll make 2 observations. One, if you have males making decisions not to hire females because they don't want to put them in the position, themselves in the position of potentially being accused of sexual harassment, they've just committed sex discrimination. Okay, so, and by the way, that's an easier standard to prove than the harassment stuff. So, I don't think that that's really fundamentally a concern. And quite honestly, I find that younger people today tend to be a hell of a lot more vocal about the conduct that goes on in the workplace than people who've been around a long time, because you grow up with different societal norms. My wife makes fun of things that I joke about because she says, that's not sexual harassment, because she comes from growing up in the business environment when, look, a lot of it was kind of a little Mad Men oriented, and she just grew up in a different environment. And today I think women put up with a lot less and are much more willing to come forward. But I don't think, at least what I've seen with our clients, a hesitancy to hire women because of that. And I think it actually, if you hire more women, your environment actually turns out to be better.
I totally agree, and I'd say I have not seen that happening yet, which is a good thing, right? Because, and I've actually advised people the opposite. So, and I think everyone up here does, companies the opposite, right? So one thing I've said, and I say it not to be political, is, so in terms of knee-jerk reactions, managers within companies sometimes have these too. And what you never want to do is have a Mike Pence rule in response to being concerned about being accused of harassment. And that would be, I don't ever spend time alone with this female employee. I don't ever, go to a networking event with this female employee. Because so Mike Pence won't go with a female who's not his wife. He won't go to an event or dinner, and that's perfectly fine personally, right? But I'm saying you never want to apply that in a workplace, because that then is discrimination outright, gender-based discrimination, and again, easier to prove, and obviously it's the wrong thing to do. But the other issues that females face in getting hired in high-level positions that relate directly to gender are not as explicit and outright, and they tend to do with child rearing and assumptions about family responsibilities. And those, in New Jersey, there have been some measures to try and protect those responsibilities as well. Yeah.
Yeah, I think the only thing I have 2 daughters who are both out of college, great girls, and both have great jobs. And I do see the difference between what my wife went through and what they went through. I guess the simplest way to say it is that, it takes time to roll a boulder up a hill. So it's just going to take time. And I think each generation, each week, each year, I think it's gotten better. I really do. I see that with my clients. I certainly think what was tolerated 20 years ago is different than what was tolerated 10 years ago is different than what's tolerated now. And I maybe I'm being optimistic, but I hope that that's not out there.
I will say that I have seen examples like the one you're talking about, where an attractive person of one sex was not considered smartly hireable by a group of people of another sex because they felt that it was too risky. And of course, that's wrong, but I think it's along the lines of everything else that we've been talking about and that I've particularly been talking about, the concepts of what we learned in kindergarten. The whole idea of what we've been fighting against in America and elsewhere for so long is the sense that there should be different treatment of different people because of their differences, right? And the key is to get away from that conceptually. It's not without its own issues because certain people presume things are going on that aren't sometimes. But the main effort culturally, in terms of the workplace particularly, is to create an environment like the Star Trek bridge from all those years ago, as Ian said, where you have a diverse community of people behaving professionally and not interacting with one another on the basis of whether they have long ears or whether they have great afros or whatever they have, right? It's about productivity, it's about how you perform, and it should always be on that basis. The beauty, to me, of the business world is that it gets to be like that a little bit more easily, hopefully, than does society at large. Those struggles are going on and will continue to go on, but in the workplace, you can control it, theoretically, and that should be the mission that we all have there.
Sir.
I'm sorry, I didn't hear.
The question is sexual harassment or anti-harassment type education provided in the middle school, high school levels? Typically, it's not that I'm aware of, and everyone else can chime in, though there are some programs that provide like a work skills preparation type programs. We partner with some programs where there are opportunities to bring that in to a degree about professionalism in the workplace, but typically, no, not that I'm aware of. Anyone else? Okay.
Your other question?
Yeah. So each of us can probably point you to our individual organizations' websites, but the EEOC actually provides a lot of information right online. So EEOC.gov has a lot of examples of sexual harassment and unlawful harassment. So that's sort of a publicly available resource. And I would imagine the state, is it in New Jersey? Would have it as well.
Yes, ma'am.
I'm curious, some of what we've been hearing about in the news really isn't so much sexual harassment as it is sexual assault. And what consistently surprises me is the choice of an employer to take on that investigation themselves versus perhaps engaging law enforcement. I mean, what's your take on when is the right time to say, you know what, it's wrong for me to do this, maybe we need to involve the outside authorities?
So the question revolved around the difference between sexual harassment and sexual assault and why an employer would undertake an investigation of a sexual assault that is work-related in some fashion as opposed to defer to law enforcement. The answer, it's a lawyer answer, is it's going to depend because, outside of like a school with children, you have no, as an employer, obligation, for the most part, to report a sexual assault on one of your employees. It's up to them to go to the police. If they say, this is what happened in the workplace, I think you have an obligation to investigate, period. If you think, as the employer, that it really rose to a crime, you could, in theory, report it, but I think I normally would advise a client to defer to the victim's choice as to whether or not to pursue the criminal complaint.
Is there any benefit to getting that documented? I was stunned when I heard Matt Lauer's, the Matt Lauer allegations, if you will, and it sounded to me like it really belonged more with law enforcement. But I'm just curious again. Is there a benefit to having that documented that you advise the employee they may want to bring that there, or is it better just to stay silent on it?
Well, the question is if the employee isn't, let me rephrase. So if the employee isn't saying that they're going to go to the police to report the assault, is it a good idea for the employer to document that the employee has decided not to do that and you've told them that's an option? I think we'd all agree that if you told them, we think you should go to the police, you should document it somehow, because you don't want to be, well, you didn't take this complaint seriously, et cetera, et cetera. I think what may be more important to document potentially is if the victim says, I'm going to the police and I'd prefer that you don't investigate it. Because there, I think you're in a really tough position. I think you have a statutory obligation to investigate it. And I've had cases like this where then what we've done is we've interacted with the police department, the prosecutor's office, because sometimes they don't want you getting involved in the investigation, but I want that clearly documented so that you don't lose the potential defenses that we've talked about earlier today.
Yeah, and one other point, remember, I know it's basic law here, but remember, their standards are different than ours. I mean, your standards are, did it happen? Do I think it's likely that it happened? I did a reasonable, prompt investigation. Theirs are beyond a reasonable doubt. Do they have the resources? There's a number of reasons why they may decide not to prosecute. That doesn't end your obligation. Just because they decided not to prosecute doesn't mean it didn't happen.
Yes, ma'am.
I just want to say something positive to end our day. We work with cultures all the time, and I think that big companies are moving way beyond prevention of harassment and discrimination. And to your point, we just say differently. I always say, my mom always said common sense isn't so common. And so they're training people on civility, not just harassment and discrimination. Like, what does it look like? What does good behavior look like? And it's almost like stating the obvious, but it needs to be stated. And then creating cultures of upstandard. So I know what I should behave like, but now I'm holding you accountable. So really creating cultures where you're free to come forward, and I'm going to hold you accountable to the behavior Ian is saying should be appropriate in the workplace. So instead of, to your point, instead of I have 4 children myself, instead of feeling, I feel like you're going into a better place where the conversation's on the table. And we just went to an event Friday where we were talking about HR professionals who are afraid to shake the trees because then it's all going to come out.
Right. It's a good thing if it comes out.
People are shaking the trees, and people are talking about stability, and it's huge in law firms.
Yeah, so yeah, this is a great point, because so the EEOC says that a compliant and effective harassment prevention effort includes anti-harassment training, civility training, and something they call intervention training. Okay, and so many of us also are equipped to do that kind of civility and intervention training. And that is really, so anti-harassment is sort of teach your employees what not to do, and civility training is help them learn what to do. And it wasn't quite as popular over the past few years because we had a very active National Labor Relations Board that was very contradictory to the EEOC on that point, meaning you can't require employees to act civilly and some other kind of crazy things from an employer's perspective, but that has changed. And so, yeah, it's certainly something you should offer in connection with anti-harassment training.
I think from a cultural perspective, this goes back to my comment earlier about being professional in the office environment. One of the things that we try to do is we try to empower people, in terms of see something, say something. Okay? It's very hard for upper management to police the conduct of every employee in the office. But you should empower your employees that when they hear something, when 3 guys are standing around, I keep going back to this, 3 guys around the water cooler or coffee machine, and they say something that's wholly inappropriate, someone who hears that should be empowered and feel comfortable turning to them and saying, hey, knock it off. It's not appropriate. It's unprofessional. It's not even getting to it can be sexual harassment where everyone's, antennas go up. It's unprofessional. This is not how we act in the workplace. And if you empower your employees to feel comfortable talking to each other about what's appropriate and what is not appropriate, your corporate culture will be heads and toes above everything else. And, you won't have some of the advancement issues that come associated with it.
Sir.
Going back to the piece regarding sexual harassment, abuse, misconduct, criminal conduct, I think part of it is it doesn't rise the level of awareness in the workplace because it doesn't rise the level of awareness, meaning that if the employer or the boss continually feels he needs to ask about these forms that so far to the correct area on a regular basis, we view that is a problem still. But if you take that conduct and put it on the train, it is clear that it is criminal conduct. And I don't think we emphasize enough on a lot of what goes on, although minimal, in most serious criminal cases, but unwelcome, non-consensual contact with certain parts of the body is a crime. It's simply a crime. And I think we minimizing that kind of workplace because of this guys who not that's not the case. That can't be criminal conduct.
Oh, it's a great point. And it also, with the community standards changing, right? Everyone should be aware, not to be sort of scary Mary about it, but that those standards directly impact how people are going to perceive physical contact. So some of our member organizations, and I'm sure you've had clients raise this too, you'll hear things like now, well, this manager touched me on the shoulder. I felt really uncomfortable. And you have to figure out what to do with that, to your point about physical contact, right? But inappropriate touching or physical contact, it's never an excuse that that's just how you are, that's just how she is, he is. I've always done it that way. I've always been like that with that group of employees. That's never going to be viewed as a sufficient excuse under the law. And I share in trainings, I go through entire days without touching a coworker. Like, it is possible if it's not part of your job responsibilities. And in a sensitive environment, it might be a good idea.
I can't think of a single set of circumstances where touching someone's rear end or genitals is a business purpose in most work environments. So kind of as part of anti-harassment training, one of the modules is there's absolutely no reason to touch anybody. You want to shake their hand, say thank you, whatever, but touching the shoulder, touching the butt, massage, go back and watch these 1950 movies, but not today. I don't understand. When I get a client calls up and says, this is what happened, like, really? In today's world, you need to be reminded about that?
Yes, ma'am.
There is something, I was at Montclair Film Institute the other day, and they did a panel on sexual harassment, and they showed some very enlightening videos called hashtag that's harassment that I would think people may want to take a look at. I'm going to try to send you the whole thing that you sent me out, because it was just enlightening.
Anybody else? Oh, sorry, sir.
You mentioned you can't verify because along the way I picked up pieces that you just documented. Is there another part of the procedure that's more protected than just documenting what you have? You cannot verify the actual.
Well, that's a good. The question was: is there something more than if you can't verify that the incident happened? Is there something more that should be done just to document it? I think there's two answers to that. One is, remember, we're in 2018. When I started doing this 20-some years ago, harassment happened verbally. In 2018, a lot of harassment happens textually, whatever you want to call it, social media, text messages. You'd be amazed how you'd say, well, why in the world would someone put that in writing if they're going to harass someone? You'd be amazed what they'll put in writing on a text message or an email. So it's just how the nature of how our younger generation talks to each other. So make sure when you're doing your investigation, it's not just looking at who said what to who, but try to gather whatever evidence you can electronic, because that's out there. But when you really are in a tough call situation, I think it is important to document the incident happened, and while you may not discipline the employee, you certainly want to remind the employee of the harassment policy. This is the policy we have in effect. Make sure you follow this going forward. Because I can tell you, if 6 months later there's another complaint against that employee, now you're going to look at it a second time and say, hey, wait a minute, maybe the first time, well, I couldn't corroborate it. Now it's, fool me once, shame on, whatever that saying is. So, so certainly I think that's why having it documented, you did an investigation, is going to be important legally, but it's also important for you to have a treasure or, a history there that you can go back to and say, hey, wait a minute, maybe now we do have a problem here.
And it's not just documenting it, right? It's behaving and following up appropriately that concludes it. It's important not to just document that you did something. You have to follow up with the parties and you have to take appropriate action. But I think your question also highlights what has been in a couple of the questions recently. The Me Too movement has spawned the idea that for smaller organizations and for organizations that may feel that they want a level of impartiality associated with it, that an independent investigation is a good idea. If you have a sensitive issue and you don't feel equipped to handle it and you're not really sure what to do and you're thinking, well, I guess I'll just document this or whatever it is, it may be that it's smart to go outside and get somebody who has expertise to do a complete investigation to protect you fully and to make sure that all the I's are dotted and T's are crossed. And that's something that we are seeing a lot more out of recently.
Well, I want to thank everybody for coming today, and I want to especially thank our panel for participating in a very thought-provoking morning. Thank you, panel. Excerpts from this morning's panel will appear in a future edition of NJBIZ, and I urge all of you to get this week's copy of NJBIZ because we do tackle the subject of sexual harassment in this week's paper. And if you're not a subscriber, please note that we are offering a free 16-week subscription to all of today's attendees. Please see Anna Acquaviva, who is our events coordinator, on your way out. And if you already have filled out a form, please leave it with her. Our next panel will be on the topic of cybersecurity, and it's scheduled for Tuesday, February the 20th. And I hope to see all of you there as well. Thank you very much for coming.
Thanks. I appreciate it. Thank you.